Hello, everyone. I think we are live. Happy Monday. I am Minerva Mims. I am from the North Carolina Real Estate Commission. I am the Commission's Diversity, Equity, and Inclusion Officer, and happy to be with you all here for Mobile Monday, the 1st of April, and very timely as we enter in Fair Housing Month. We are going to talk about some fair housing topics. If you have questions, you can put them in the chat as I am presenting, and I will try to get to them. But with that said, I will go ahead and get started. Today, we are going to take a little bit of a different approach to talking about fair housing. We're going to look at some of the history behind it and how we kind of arrived to the passage of the Fair Housing Act. And then we're going to talk about kind of your rights as a consumer, your obligations as a realtor, and kind of the commission's role in all of that. So a brief history surrounding the Fair Housing Act. The Fair Housing Act was passed in 1968, and coming off of the heels of the passage of the Civil Rights Act of 1964. And at that time, the country was experiencing just a lot of community violence, intimidation, and restrictive covenants, really because the Civil Rights Act of 1964, it explicitly prohibited discrimination and segregation in public spaces, education, employment, housing, and that trickle effect led to the community violence and intimidation that we saw in our country. So also at this time, while the Civil Rights Act of 1964 had prohibited discrimination in housing, there was also a new initiative that came forward during this time called redlining. And essentially what redlining was, it was where banks through the Federal Housing Agency Administration, which is FHA, were only administering residential mortgages in areas that were deemed economically sound. And what that translated to is in communities that were primarily white, did not have people of color, and they did not issue loans in those areas where a lot of Black and brown people and people of color live. And so while the Civil Rights Act of 1964 made it illegal to discriminate, there was sort of a governmental policy that undermined what the Civil Rights Act of 1964 did. And really quickly, I kind of wanted to show something here. Okay, perfect. What I have before you is a map, and this is in Durham, North Carolina, so right here in our lovely state, that was used during this time to identify communities. And essentially what they did is they graded these communities based on who lived there, the work that the workers in the community did. So if we look here, you see that there are different categories. You have your best, still desirable, definitely declining, and hazardous. So if we look here at our hazardous areas, what they clarify by saying this area is occupied mostly by Negroes of lower class, and there are few fairly decent homes in this particular area. And so what they would do is they would use this information to deny mortgages to people of color and limiting their housing availability and resources. So that's some of the things that were going on then. And so in addition to the Civil Rights Act of 1964, prior to the Fair Housing Act being passed in 1968, there were several attempts to get the Fair Housing Act passed. I believe from 1966 to 1968, there were at least two attempts to have the Federal Housing Act passed, but it failed each time. What was the catalyst for the passage of the Fair Housing Act was the assassination of Dr. Martin Luther King Jr. in 1968. And that was used to usher the passage of the Fair Housing Act in 1968, just because the climate of our country was just so very was very fragile, and that was just a prime opportunity for President Johnson to usher in that bill and have it passed into law. I think it was 7 days after the assassination of Dr. King. So, talk a little bit about the history of the Fair Housing Act. So, what are fair housing laws, right? These are laws that protect consumers from unfair practices and housing-related transactions. So, some of the protections that you get under the Fair Housing Act is it makes it prohibits and makes it illegal to discriminate in housing and related transaction based on one's status in a protected class. I hope that you all can see this chart, but I created a nice little chart that kind of outlined the characteristics of a protected class. And we have our race, we have color, national origin, sex or gender, we have familial status and disability. And if you look to the right, you'll see that there is the federal and the North Carolina, because in addition to the Federal Fair Housing Act, we know that we have North Carolina has the Fair Housing Act as well. So I've identified what the federal law says and what North Carolina law says, and they are all the same, with the exception is under the Federal Fair Housing Act, it includes sexual orientation, gender identity, and sexual orientation, and that is not included here in North Carolina under our Fair Housing Act. So we talked about housing and related transactions, and what that looks like is it's going to be rentals, sales, financing, purchasing, constructing, any improving, repairing, maintaining, and appraisals of residential properties. This is going to be residential only. Fair housing does not apply to the commercial space. There are other laws that provide protections there. So I want to talk a little bit about your obligations as the realtor, as you're representing your clients. You represent your clients, but also you need to represent your best interests in your transaction. So even if your client tells you, you know that you cannot refuse to sell, rent, or negotiate housing based on someone's status in a protected class. We know we cannot discriminate in the terms, conditions, or privileges of sale or rental of a dwelling. We cannot misrepresent availability. We can't make statements that indicate any sort of preference or limitation based on one's status in a protected class. Of course, we can't curse, intimidate, threaten, or interfere with a person's right to fair housing. We cannot harass, or we cannot otherwise make unavailable or deny housing for housing that would generally be available. We talked about, some of the things, your obligations and what you cannot do. So here are some of the things that really you should be doing as a realtor and as you're representing your clients. You want to make sure that you have clearly written policies and procedures that comply with fair housing. And you want to follow those without deviating from what's outlined, because a clearly written policy is your best protection. So I want to make sure that you have those policies. In addition to having those policies, make sure that as you're bringing in new people into your team, they're signing that they have read over and agreed to the terms that are stated in your policy. Because then that provides you another layer of protection. And not only do they read and sign those policies and procedures, you're enforcing it, right? So if there are any violations of your company policies and procedures, you have a zero tolerance as it relates to fair housing, and that you follow that across the board with everyone in your firm. And then also making sure that you are documenting any appropriate disciplinary action if there are any violations, because again, this is just another layer of protection for you and your firm. And if you have someone who is consistently violating, right, you want to make sure that you are cutting ties with them as a layer of protection for yourself. And then as you're dealing with your clients, just goes back to being consistent in your dealings across the board with all of your clients and prospective clients. So we talked about how you represent your clients. Want to talk about what it looks like to violate, right? So sometimes people say, well, I didn't do anything, right? Well, your action or inaction, whether it's intentional or not, if it has a discriminatory impact against a person in a protected status, in a protected class, that could be considered a violation of the Fair Housing Act. And like I said earlier, it's not a defense that, well, I didn't know, or my client told me to do this, or my client instructed me to do that. It is up to you to use sound judgment and know what the law says you can and cannot do, and make sure that you are not violating it, even if it's at the direction of your client. And if you have clients who would urge you to break the law, then it will be worth cutting ties with those clients. It's not worth it in the long run, because there are impacts to you professionally that you don't want to take on, and sometimes even civilly or criminally, depending on what the violation is. So as we're looking at the rights for consumers, anyone in a protected class can bring a charge of discrimination when they have been harmed by being discriminated against under Fair Housing Act. They have a year to bring their charge, and it's a year from the discriminatory action. There is no statute of limitations with the commission. So if a consumer has an experience with a realtor and they want to file a complaint with us, there is no statute of limitations. They can file a complaint at any time. There are civil penalties that can be administered if you're found in violation of the Fair Housing Act. I mean, those penalties can be pretty steep, and they can be up to $50,000. So talking about kind of some of the work that the Real Estate Commission does to further fair housing, we have enacted rulemaking that speaks to licensees' conduct that may violate state fair housing. And we have 4 particular rules here, and I won't read them. I'll provide this slideshow so you guys can kind of reference them as you see fit. But we do have 4 rules here. We have our fair housing, we have our prohibited acts, and we have disciplinary action, which says that if you are found in violation of the Fair Housing Act, that the Real Estate Commission does have a right to administer some sort of disciplinary action, investigate and administer disciplinary action as necessary. This one here is probably the biggest one, and I'll call this one out specifically because it deals specifically with verbiage that you have to use in all of your listing agreements, all of your buyer agency agreements, and other agreements that you have for your services. And it's just basically saying that you as a broker shall not conduct brokerage activities in a manner that is discriminatory. It is very essential that all of your documents have this language in it to provide yourself with some protections. I've listed a lot of information here, but I always recommend that you consult the resources available to you. There are a ton of free resources and trainings that are available to you to really just help you gain some awareness and education about the details of what the Fair Housing Act requires. It's very nuanced. And it can get pretty tricky. I know that there are oftentimes questions regarding disability, reasonable accommodations, service animals, emotional support animals. And there are free resources and free trainings available. The Legal Aid Fair Housing Project here in North Carolina, they offered free training online that go into specific topics I believe they do it monthly. So these are just some resources that are available to you all. And I highly recommend that you consult them. That is all that I had from our presentation today. But I will be happy to take any questions that you all may have. Seeing that there are none, I thank you all for your time. Thank you again for inviting me out. I hope that you all have an amazing afternoon, and thank you.